Baker Botts, LLP, provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney-client relationship. This communication may constitute attorney advertising.
Welcome to the Lawful Influence podcast, where we pull back the curtain on legal issues in the world of campaign finance and lobbying. I'm your host, Sterling Marchand, coming to you from the epicenter of lobbying, Washington, D.C. In this episode, entitled The Oppenheimer of Advocacy, we will be discussing the Lobbying Disclosure Act, or the LDA. As we've talked about before, the name of the game in lobbying is disclosure and transparency. And so the LDA is the statute that regulates federal lobbying, including the requirements that lobbyists register with the House of Representatives or the Senate, and the requirements that lobbyists regularly report on their activities and political contributions. Now, the LDA can be a complicated statute, and it has a number of arcane definitions, and with every general rule, there are a number of exceptions. And so, much like an atom bomb, we're going to deconstruct this into three levels and try and keep it simple. But the first is what triggers the LDA? What starts the process whereby a lobbyist would need to register? And then once that chain reaction starts, what are the immediate effects? And finally, what are the long-term repercussions or some other less obvious effects on you and your business if you go down the path of lobbying? Once you are armed with all of those facts, you'll be in the best position to decide if lobbying is the right course for you. And if you want to avoid lobbying, we'll discuss the best ways to do that as well. But what you don't want to do is to stumble into lobbying. And it happens a fair amount more than you would expect. Because, as I said, there are immediate and long-term repercussions in legal liability once you cross the threshold and become a lobbyist. So to get started, let's discuss what triggers the LDA. So under the LDA, a lobbyist is any individual who meets three elements. The first, a person that is employed by a client for compensation. Basically, if you are an organization and you have an employee who you pay, this first element is going to be met. And we're going to be talking primarily about organizations that employ in-house lobbyists, and the rules for lobbying firms are just slightly different. The second element of a lobbyist under the LDA is someone whose services for the client includes or is expected to include making more than one lobbying contact. And we'll talk about what a lobbying contact is in a few minutes. The third element is that that person must engage in lobbying activities in excess of a time threshold, and that's 20% of their time in services for the client over any 3-month period. Now, once all three of those elements are met, a compensated individual who makes more than one lobbying contact and whose lobbying activities are in excess of the 20% threshold, then that person is considered a lobbyist under the LDA. An organization who employs at least one in-house lobbyist is required to file what's known as an LD1 form. And that's basically just a registration form that gets filed with Congress and provides basic information about both the organization and the individual lobbyists. That registration requirement, however, is only triggered if the total expenses for lobbying activities exceed or are expected to exceed $14,000 in a quarterly period. For lobbying firms, that income threshold is much lower. It's roughly $3,000. Now, again, each of these elements seems straightforward, but we want to discuss two of them in more detail. For the second element, the requirement that there be two lobbying contacts. That term, a lobbying contact, is defined as any oral, written, or electronic communication to a covered executive branch official or a covered legislative branch official. And just to make this simple, first, oral, written, or electronic communication is exactly what it means. You make a phone call, you write an email or a letter, you convey something to the person in person. All of that is going to be a covered communication. One thing you might not be thinking about, however, is social media. In today's world, you can message covered legislative officials directly. You can DM them, you can tweet at them, and depending on the nature of the communication, that may also be a lobbying contact. Now, it's not just any communication with a covered executive branch or covered legislative branch official. It has to be with regard to certain specified topics and not otherwise subject to an exemption. So, to simplify this, really, the issue is twofold. Is the person you're communicating with covered? And is the content of the communication considered covered advocacy? Now, a covered legislative branch official is very straightforward. It's pretty much members of Congress and their staff, any elected officers of the House or the Senate, and committee or leadership staff. So pretty much anyone working in Congress, either here in Washington, D.C., or in member offices around the country. A covered executive branch official is a little bit more nuanced. It includes very obvious examples like the president or vice president, certainly cabinet, secretaries, high-ranking officials. The exact definition is that it's any officer or employee in levels 1 through 5 of the executive schedule, or any Schedule C political appointees, or any member of the uniformed services above a certain rank. One practical tip to determining whether or not the person you're speaking to is a covered executive branch official is to check what's known as the Plum Book, called that because it has a purple cover. Every 4 years, the GPO prints this book that contains all of the positions within the executive branch, both by title and by name, and lists what level they are at. So it's very easy to see whether the person you're meeting with, either by name or by title, falls into one of these levels or is a Schedule C political appointee based on the information in the Plum Book. Once you've determined that the person you're speaking to is a covered executive branch or legislative branch official, then the next question is whether the content includes covered communications. And really what this comes down to is any discussions about the formulation, modification, or adoption of federal legislation, a federal rule, regulation, executive order, or any other program, policy, or position of the United States government is going to be covered. So if you're meeting with a congressman and advocating that he or she vote a certain way on a bill, that is going to be a covered. It also includes the administration or execution of a federal program or policy. So if you meet with a Department of Energy official and are advocating for a change in the way that a federal program is being run, that, depending on the level of the person you're meeting with, also is likely going to be a lobbying contact. It also includes discussions about the award or administration of a federal contract, grant, or loan, as well as the nomination or confirmation of individuals for a position by the Senate. So it's a very broad definition in terms of the content that it covers, but there are approximately 20 or so exceptions to lobbying contacts, which includes things like public communications, and those are statements that are made in a speech, an article, or a publication. That includes testimony before Congress. That's not going to be considered a lobbying contact under the LDA, or some other written comment that's filed in a public proceeding. There's also a category of exemptions that I think of as requests for information. So if you reach out to a covered official and you request a meeting, and it's simply an administrative request, that's not going to be a lobbying contact. If you're providing information in writing in response to an official asking you for specific information, that is also not considered a lobbying contact. When it comes to rulemakings, where the request for information is published in the Federal Register or something analogous, your comments on those proposed rules, if directed to the appropriate official, would not be considered a lobbying contact. Most proposed rulemakings designate a specific person within the agency to receive comments on proposed rules. And as long as you're providing comments or feedback to that person, it will not be a lobbying contact. However, if you are advocating for changes to a proposed rules and you're making it to someone else, someone higher up the chain, a secretary or assistant secretary, then that is likely going to be a lobbying contact. There's a couple other categories of exemptions that include things like judicial and adjudicatory communications. This is when you're providing information that's required by law or subpoena or made in connection with some judicial proceeding, as well as certain protected communications. Whistleblower communications come to mind. If any of these exceptions apply, and it really is a highly fact-specific determination, then that communication is not a lobbying contact and does not count for the second element in determining whether or not you're a lobbyist. The third element under that definition of a federal lobbyist requires that the person's lobbying activities constitute 20% or more of their time over a 3-month period. It's important to note that lobbying activities is broader than lobbying contacts, and it includes time spent preparing for or in anticipation of making such contacts. So, for example, it includes things like reporting on or monitoring pending legislation. It includes drafting talking points or doing research on an issue that will support lobbying down the road. And it also includes things like meetings to develop a lobbying strategy. Now, the key here, because it's a very specific requirement in terms of meeting this 20% threshold, is really to keep track of your time. Find a way, if you use a software to track time, to code certain time entries. There's a number of ways that you can do this, but you want to basically be able to distinguish between time that is spent on lobbying activities versus non-lobbying activities. And that way you can watch the 20% threshold. And tracking your time is going to come in handy down the road if you reach the point where you are registering as a lobbyist, because as we'll talk about in a few minutes, organizations have to report their lobbying expenses, and that includes a percentage of the compensation that is paid to their individual lobbyists, again, for time spent on lobbying activity. So I often get asked, how can I avoid becoming a lobbyist? And really, it's pretty simple. Don't make more than one lobbying contact. Remember that contacts with executive branch officials that are lower than that level 5 on the executive positions don't count as a lobbying contact. So a lot of times you're able to communicate with folks in the executive branch, have conversations about changes to policies or programs, and it won't count because it's not a covered official. When it comes to Congress, as I said earlier, almost everyone who works in the legislative branch is covered. And so if you're going to be having communications with Congress about potential legislation, then in all likelihood, it's going to be a lobbying contact. The other ways you can avoid becoming a lobbyist is to keep your time on lobbying activity low relative to the other work that you do. For in-house lobbyists, this can be relatively easy. If you have multiple job responsibilities, then all you have to do is make sure that the lobbying portion of it remains under 20%. For outside lobbyists at a lobbying firm, this is going to be very difficult because most of the time they are going to be retained solely for the purpose of lobbying, and all of the work that is done for that client will count towards lobbying activity and will quickly exceed 20% of your time. Otherwise, the only way to do it is to be a pro bono lobbyist, basically do the lobbying for free and not be compensated for it, or as an organization to ensure that you don't exceed spending $14,000 in a quarterly period. Again, when you factor in things like lobbyist compensation and expenses, that can be a really hard threshold to stay under. I know we went very quickly, but that's the basics of what triggers the LDA. And once you've met all three of those elements, you are a lobbyist under the LDA. And there are immediate impacts that immediately sets off a chain reaction in terms of what you have to do, and the timing is important. As we talked about earlier, for that second element, you don't actually have to have made a second contact. You just have to reasonably expect that you're going to make a second contact with a covered official. And so if your boss comes and tells you, hey, I want you to go and meet with this congressman this week, and 2 weeks from now, I want you to follow up with him or her, that's enough. That's enough for you to know that you're going to, again, assuming that the other elements are met, that's enough for you to know that you're a lobbyist. That's when the countdown clock starts for registration. And so it's really important to understand what triggers that. So once you've crossed that lobbying threshold, there's no turning back. It starts off this chain reaction of requirements that will go on in perpetuity until you file a termination notice. And so again, the first thing that your organization is going to have to do is they're going to have to register. And that must take place within 45 days of whatever the triggering event is. Often it may be the second lobbying contact or crossing that 20% threshold or the $14,000 threshold for organizations. Once you've registered, you have an obligation to periodically report and disclose your activity and political contributions. And those requirements apply both to the employer of the in-house lobbyists and to the individual lobbyists, as we'll talk about more in a minute. Now, that first LD1 form, that registration form that the employer files, it includes information about the registrant company and information about each employee who has or is expected to act as a lobbyist on behalf of the company. And there's a number of particular disclosures that have to be made in that initial registration. And to be honest, I see a number of mistakes that come up more frequently than others when it comes to registration. And so I just want to briefly cover those. The first common mistake is failing to disclose previous covered employment. There's a requirement under the LDA that registrants disclose employment in the legislative or executive branch in the past 20 years. So if you've hired a Hill staffer into your organization who's going to be lobbying, you have to disclose who or what agency they worked for. And that is an ongoing requirement that you keep that up to date as you bring on new lobbyists. Another common mistake is that registrants fail to identify what are known as affiliates and contributors. Organizations are required to identify any other organizations that contribute more than $5,000 in a quarterly period to fund lobbying activities and that actively participate in the planning, supervision, or control of such lobbying activities. This is especially important for trade associations who may have a portion of their fees designated for lobbying, may have a board of directors who provides direct input into what lobbying is going to be done. And in those instances, the registrant must identify who those affiliates are and who those contributors are. Another common mistake is failing to identify foreign entities. Again, the LDA requires that registrants list all foreign entities that are 20% or more equitable owners of the registrant and that directly or indirectly plan, supervise, control, or finance the activities of the registrant and has a direct interest in the outcome of the lobbying activity. This is a very common requirement that is overlooked by registrants, but it is something that both the House and the Senate and eventually DOJ take a very close look at when they're looking as to whether or not a company has complied with the LDA. The final common mistake that I see on registration forms is failing to identify prior convictions. There was an act passed a few years ago that's commonly known as the JACK Act. But basically, when you register as a lobbying organization, you must identify any listed lobbyist who is convicted of certain offenses involving bribery, extortion, embezzlement, illegal kickbacks, tax evasion, fraud, false statements, perjury, or money laundering. Most of the time, you make the disclosure and that's it. You don't think about it again, but there is an ongoing requirement to keep that up to date and to include that on your quarterly activity reports as well. So it's really important that you are aware of prior convictions of your employed lobbyists, but also that you disclose it. Once registered, an organization employing lobbyists and the individual lobbyist must make regular disclosure reports. Now, the organization must file what are known as quarterly activity reports. The individual lobbyists don't file this. This is something that the organization does on their own. In it, the organization will identify for that quarter the general lobbying issues that the filer engaged in, the specific lobbyists who had activity during that quarter. It identifies the houses of Congress and the federal agencies that were lobbied, and it identifies specific issue areas, including, for example, a list of bill numbers in which a lobbyist engaged in activity. The report must also disclose a good faith estimate of the total expenses that the company and its employees incurred in connection with lobbying activities. And I'll pause there for a second because I said lobbying activities. And again, remember, lobbying activities is a broader term. It's not just lobbying contacts. It means all of the support work that went into producing those lobbying contacts, researching, writing, all of that, strategizing. You have to be able to account for that. And that's why time tracking of your employees, not just lobbyists, is so important. Finally, the quarterly activity report, as I alluded to earlier, must include a description of the interest of any foreign entities and the disclosure, once again, of the JAC Act convictions. So you want to stay on top of those. You want to make sure that those are being included in your quarterly activity reports and not just being disclosed in your registration. In addition to the quarterly activity reports, all lobbyists and registrants must file semi-annual contribution reports. These are done twice a year, January 30th and July 30th, and they cover the preceding 6 months. These forms must include detailed information about certain contributions or expenses related to covered officials and political contributions made by the filer or a political committee established or controlled by the filer during the reporting period. What does this mean? So if you're an organization that has its own political committee or a PAC, you must make disclosures in this lobbying form about the contributions that your PAC made during the relevant period. Yes, this is double reporting because you're reporting it already to the Federal Election Commission, but the Lobbying Disclosure Act wants you to report it here again. And it goes into a separate database that's maintained by the House and Senate. And anyone can look up and see this lobbying organization made these contributions. But critically, these semi-annual contribution reports are also required for individual lobbyists. And so if you are an individual who is lobbying, you have to keep track of what contributions you made, and you have to disclose those as well. And again, it's also other expenses related to lobbying. There's a long laundry list of things that must be included in this semi-annual contribution report. It's really important that you take a look at that and make sure that you're tracking it throughout the year. There's another critical part of the semi-annual contribution report that I want to touch on just briefly. And that's in about 2007, the law was amended to require a certification that the person filing the report has read and understands the gift and travel rules in the House and Senate, and that the filer has not knowingly violated such rules. So we'll talk about it in a little bit in more detail, but as a lobbyist, you are subject to different rules about what you can provide to covered officials under the existing ethics rules. And so what this certification is saying, you're signing under penalty of law that you know what the rules are and that you have not knowingly violated those rules. So for an individual, that might be relatively easy, but for an organization, it becomes much, much more complicated. And so for organizations, what I typically recommend is that you include in your compliance policies detailed information about who can provide gifts to covered officials, when, requiring that they be approved in advance, that you provide training to your employees on these policies, and that you conduct regular compliance surveys and audits. Because ultimately, as an organization, when you're filing this semi-annual contribution report as a lobbying organization, someone is going to have to sign that provision, and someone within the company will have to be comfortable that no one in the company has violated the rules on behalf of the company. And that can be a big ask of a person, but with the right policies, the right training, and the right audits and surveys in place, you can get to a place where you feel comfortable doing so. So just some quick basic tips in terms of how to make these reporting requirements easy. Again, track your lobbying activity. I really can't stress this enough. Once you have in place a method for all of your employees to track time and allocate it to lobbying activities, it makes not only determining whether or not you've crossed the 20% threshold easier, but it also makes it easier to provide that good faith estimate of the expenses that your organization has spent on lobbying activities in any given quarter. The same is true for tracking contributions. You want to ensure that your company has a way, a method in place of surveying folks and asking whether any contributions have been made. Oftentimes that's done by requiring pre-approval so that it is all being funneled through one person or one office so that they can track it and that it is properly reported. And the last thing that I'll touch on today, although there's a lot more tips that we could cover, is to maintain documentation. Companies must keep paperwork supporting their filings and demonstrating the due diligence that we've been talking about for about 6 years after the report is filed. So that's the immediate effects of triggering the LDA. Again, once you register, you are required to file quarterly activity reports and semi-annual contribution reports until you terminate. And that's true regardless of whether you lobby ever again. If you have no activity, you file a quarterly activity report saying no activity. And if you have no contributions, you file a semi-annual contribution report saying no contributions. You'll still be certifying that you have complied with the gift and travel rules under the House and Senate. So in the little bit of time we have left, I just want to cover briefly those long-term repercussions. So now you've registered as a lobbyist, you've gotten into the rhythm of filing your reports and your disclosures on a quarterly and semi-annual basis. What are the long-term repercussions of being a lobbyist or being a lobbyist organization? And this really often comes up in the context of other laws that have incorporated requirements or restrictions on lobbyists. The biggest one is going to be the impact on federal grants and loans. There's a provision of law that prohibits the use of federal funds, like grants and loans, to influence an officer or employee of any agency regarding federal awards. And applicants, if you're a company that routinely applies for grants or loans, you want to be critically aware of this because you have to disclose additional information during the application process regarding your lobbying. And you have to certify that you haven't violated this provision. So if you're receiving as a company grants or loans from the federal government, you have to be able to show that none of that money was spent on lobbying. Another big requirement that comes in terms of long-term repercussions for being a lobbyist is the impact on the gift and ethics rules. As I alluded to earlier, lobbyists and organizations who employ lobbyists are prohibited from making gifts. If you don't know what I'm talking about when it comes to ethics rules, go back and listen to my episode from Christmas where we talk about some of the basic restrictions around providing gifts and travel to officials. All of those rules have a little asterisk next to them because once you become a lobbyist, the exceptions reduce about tenfold. And lobbyists are essentially, with a few exceptions, prohibited from providing gifts and travel to covered legislative branch officials. Remember that semi-annual certification is required saying that you have understood and have complied with the gift and travel provisions of both the House and the Senate, and that you're not violating them. As a lobbyist, you're also prohibited from taking certain trips with covered officials. So it's really important that you go and look at the ethics rules and look at how it applies to lobbyists in particular. And finally, the last long-term consideration that you want to have is that once you've filed as a lobbyist, once you're registered as a lobbyist, you are required under law to identify yourself as such when you communicate with covered officials. And so you have to disclose at the start of the meeting, if it's not already apparent from some other communication, I'm a lobbyist. I lobby for this organization, and we're having this meeting in that capacity. So look, we're already way over time. I know there's a lot more we can cover on the topic of lobbying. We could cover the differences between federal lobbying, which we just spent our time discussing, and state lobbying. Each of the states is different, although they fall into some similar buckets. But there's differences and nuances. If you're doing state level lobbying, I can't stress this enough. You've got to do your homework and your due diligence and look at what's required and what it means in the long term for your business in terms of being able to do business in that state. The other thing that we will discuss in future episodes is what it means when a foreign company lobbies in the US or directs someone in the US, like a US subsidiary, to lobby. In that case, it can implicate not only the LDA, but also the Foreign Agents Registration Act, or FARA. It's been getting a lot of press lately as the government has investigated and prosecuted FARA violations. As I mentioned, we'll talk about that in a future episode. Just in the meantime, remember, if you trigger the LDA, you want to be fully aware of the immediate impact and the long-term implications. If you do that and you stay up to date on your disclosures, you'll stay on the right side of lawful influence. Until next time, I'm Sterling Marchand.
Thank you for listening to this Baker Botts podcast. Baker Botts has the experience, knowledge, and people to address our clients' most significant legal issues. For more information on Baker Botts practices, please visit us at bakerbotts.com. This presentation is provided by Baker Botts, LLP, for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.